Hello, I'm David Pollard. I'm a barrister from Wilberforce Chambers in Lincoln's Inn. This is one of a short series of webinars in relation to various technical aspects, mainly of pensions law. This one's looking at TUPE and pensions, the transfer of undertakings, protection of employment regulations, in particular focusing on one particular point. This is quite a wide area. Does TUPE automatically transfer pension benefit obligations in a private sector pension scheme? So that's one established under trust, where the obligations are not owed, it's a matter of English law, not owed by the employer, but owed by trustees separate from the employer. Does TUPE operate to transfer those? Spoiler alert, no, I don't. I think it's highly arguable they don't. This is a short webcast, just focusing on that. I'm going to hopefully come in at under 10 minutes. This is just a discussion, it's not advice. If you're not a solicitor, then go and ask from legal advice from a solicitor. If you are a solicitor, then consider formally instructing a barrister. There is a lot of detail in some slides, which are available on the link up there or down there or somewhere. And we'll give more detail of the cases and the legislation. So I'm looking at the TUPE regulations 2006, the transfer of undertakings, protection of employment regulations 2006. They were enacted to reflect the EU Acquired Rights Directive 2001, that's the ARD, and they replaced earlier directives and earlier statutory instruments. They're still in force, despite Brexit. It's part of retained European law. TUPE and the Acquired Rights Directive operate in fairly simple fashion. If there's a relevant transfer of a business or undertaking or a service outsourcing, then most of, come back to that, the rights and obligations as between the current employee and the employer transfer automatically to the new employer, the transferee, transfer from the transferor to the transferee. So in effect, there's a statutory novation without the consent of the parties. Employers in ease can object to the transfer if they want. This is sort of like a Wurzel-Gummidge effect. The business, the employees, the body continues, and the transferor's head is replaced by the transferee's head, so the seller purchaser. TUPE's also got other provisions dealing with consultation, information, things like that. I'm not going to deal with those. I'm just looking at the particular obligation, the main obligation in Regulation 4 of TUPE, which is the effect of a relevant transfer on contracts of employment. Now, what Regulation 4 says that unlike the common law, contracts of employment don't terminate where you've got the relevant transfer of the relevant employees. Instead, the contracts of employment continue. And then Reg 4.2 says all of the transferors, it's the old employers, rights, powers, duties, and liabilities under or in connection with any such contract shall be transferred by virtue of this regulation to the transferee. So this is two-party obligations. Employee transferor transfers to transferee under the regulations. Now, there are obvious problems, or if there are any issues in construing Regulation 4, then we have to follow an EU retained law purposive approach, but that can't go too wide. We've got to give some meaning to the words used. So what does that mean in relation to pension obligations, where the pension obligation is owed by trustees, it's not owed by the employer? There's the UK case law's fairly clear on that. Does the obligation transfer? Well, the plain wording of Regulation 4 and indeed the plain wording of the Acquired Rights Directive, Article 3, is fairly clear. It's only the transferor's rights, powers and duties that transfer. It's not any third-party obligations like trustees that are out there. And there's clear authority now that came in a few years ago in KIrtruna from the European Court of Justice, then the highest court we had on this, talking about third-party liabilities. In that case, it was a lease, and they said that didn't transfer under TUPE, even though it arguably was under in connection with a contract of employment or affected the employees. If the lease didn't transfer, that did not transfer. Now, there's an earlier Court of Appeal decision, Bernadone, dealing with employer liability insurance, where the UK Court of Appeal did say that it thought third-party liabilities transferred. Did this in just 2 paragraphs. Quite a major step for the Court of Appeal, and the reasoning isn't that brilliant, I don't think. And in any event, it's before KIrtruna, which says no, you just got to look at the words of the Acquired Rights Directive. Now, being definitive in this area isn't going to need a court decision, but it seems to me that the arguments are stronger that KIrtruna will be followed than that Bernadone will somehow extend third-party pension liabilities. So it seems to me that it's certainly more arguable than I thought it was before KIrtruna that Regulation 4 doesn't operate to transfer third-party obligations. Now, Regulation 10 of TUPE, again following the Acquired Rights Directive, does have a carve-out for pensions. Taking this view about Regulation 4 doesn't mean Regulation 10 has no ambit. It could still apply if there's a contractual obligation to provide pensions. Those are pretty rare in the private sector, probably more common in the public sector. And there you can say Regulation 10 carves out pension obligations. And then there's a further limit that's only got to relate to old age, invalidity, or survivors. And that's mainly what the case law has focused on. So I don't think that's not a reason for saying Regulation 4 does apply. So it's got to be an obligation of the transferor. In a private sector pension scheme in the UK, it's pretty clear as a matter of English law that the obligation is on the trustees, it's not on the employer. So Lord Millett in Air Jamaica and Charlton, the obligation to make pension payments was not a contractual obligation undertaken by the company, but a trust obligation imposed on the trustees. So that's fairly clear. And the fairly plain meaning of the Article 3 of the Acquired Rights Directive, Regulation 4 of TUPE, is that only the transferor's obligations transfer. We look at the Acquired Rights Directive, the transferor's rights and obligations arising from a contract of employment or from an employment relationship shall by reason of the transfer be transferred. So transferor is the old employer. That's not inconsistent with the Beckman and Martin decisions, which were themselves, there were questions asked in Beckman and Martin. We're looking at public sector schemes, looking at ones where there seemed to be an obligation on the employer in relation to pensions to reimburse the NHS scheme. And they didn't really answer the questions particularly about whether it was only obligations on an employer that transferred because of that situation. Procter & Gamble, the only other place that really discusses this in a UK context, a decision of Mr. Justice Hilliard a few years ago, was looking at a contractual arrangement between two employers, between the transferor and the transferee, and the issue about whether or not the pension benefits transferred was actually conceded as a result of that, although it was discussed by the judge as being a grounds for distinction between this case and Beckman and Martin. So it wasn't actually argued, was conceded, so it's not authority for an issue where it's being conceded. So if we look at other case law, there is some case law on third-party obligations, but it's fairly limited. At things like profit-sharing schemes and share options. So French and Mitty looking at a profit-sharing scheme, but that was an obligation of the employer, not an obligation of a parent or something like that. There's an interesting case in 1987, Chapman and CPS Computer, looking at share options granted by the parent company. And the Court of Appeal there said, well, that meant TUPE didn't apply to them at all. The regulations have no effect. They are totally irrelevant to the contract with the parent company. So fairly clear steer by the Court of Appeal there, not cited by the Court of Appeal in Bernardone. Franklin, a decision of the Employment Appeal Tribunal. Then Beckman and Martin themselves, as I've said, not really focusing on non-NHS schemes. Beckman and Martin saying, well, the obligation here was within the practical arrangements of the transferor because they reimbursed the NHS pension scheme. So fairly difficult to apply in a private sector context where there's a separate trust. Procter & Gamble, as I mentioned, dealing with issues between two employers, and the point was conceded, and that's therefore not binding, even if it was binding as a first instance decision. So going to Bernardone looking at employer liability insurance, a tort claim of an employee against the transferor, was held that did transfer. Well, it's an obligation of the transferor, and it's undrawn in connection with an employment contract. That looks fairly clear. One of the issues was, well, if that transfers, what about the trustee insurance that the old employer had relating to claims by employees? And the Court of Appeal said, for fairly pragmatic reasons, well, that transfers as well. But the reasoning's not wonderful on this. No citing of Chapman, for example. And in any event, if we look at KIrtruna a few years later in the European Court of Justice, as I said, a lease which wasn't transferable held it didn't transfer just because that would have helped the employees. So in the interest of the employees, it did transfer, but the European Court said, no, we can't go this far. So arguably being definitive in this area is going to need a court decision. Has to be said, the argument seems stronger to me that KIrtruna will be followed and not Bernadone on this point, and that therefore third-party pension liabilities probably don't transfer, but we need to see what the case is said on that. So it's a tricky area, but I think we need to pay more attention to this when looking at TUPE transfers. I hope that's helpful. As I said, slides with more detail up there or down there on the links. And thank you very much for listening.